Hello friends, welcome back again. Today we are going to see what are the different kinds of contract. On the basis of validity, on the basis of formation and on the basis of performance of the contract, there are different kinds of contract. On the basis of validity, the contract can be valid, void, illegal and unenforceable. On the basis of formation or mode of creation, the contract can be express contract or implied contract. And on the basis of performance, the contract can be executed or executory contract. Friends, as we have already seen, the agreement, if it is enforceable by law, can become a contract. For any contract to be a valid contract, all essential elements must be present there. Now, what is mean by valid contract, you might have thought. Today, we are going to see what is mean by valid contract. An agreement enforceable by law is valid contract. It means if all the essential elements which are mentioned in section 10 of Indian Contract Act 1872 are present there, then only the agreement will be a valid contract. Example, A offers to sell his house for rupees 10,000 to B, and agrees to purchase the house for that price, then the contract will be called as a valid contract. Thus, a contract to enter into contract is not a valid contract because in that case essential elements might be missing. So friends, if all the essential elements are present there, then the contract will be a valid contract. Next is void contract. A contract which ceases to be enforceable by law, it becomes a void contract when it ceases to become enforceable. Yes, firstly, there is a valid contract. If some of the essential elements are missing later, then the contract becomes unenforceable at law and then it becomes void contract. A contract without legal effects will be nullity. So, at the time of making the contract, if it is a valid contract and later on certain defect arises or certain enforceability arises, then the contract becomes a void contract. For example, at the time of entering into contract, the party to the contract was competent enough. But after making the contract, the party becomes incompetent. In that case, the contract becomes void contract. Void contract is not necessarily unlawful, but it is destitute of legal effects. Means it cannot create legal effect. Thus, the law will not enforce such contract, nor it can be made valid by the parties. The void contract should be distinguished from the void agreement. We already seen that there are certain agreements which are expressly declared as a void as per the Indian Contract Act. Those void agreements must be distinguished from the void contract. If the essential elements are missing, if the agreement is not enforceable by law, then the agreement will be a void agreement. But if essential elements are present and the agreement is enforceable by law, there will be a contract first and that contract will be a valid contract. And if later on, due to certain changes in the situation or changes in the circumstances, the contract becomes void contract, then we call it as a agreement or contract which ceases to be enforceable by law. An agreement which is void never matures into a contract. If the agreement doesn't fulfill the essential elements of the contract which we have discussed earlier, then it will not create into a legal contract. An agreement which becomes illegal in the course of performance ceases to be a void contract, while an agreement which is null and void ab initio is a case of void agreement. Means an agreement which is unenforceable or which all the essential or some of the essential elements are missing from the beginning only, then that agreement will be void ab initio, means void from the beginning only. In that case, we call it as a void agreement. Only when any agreement turns into contract, valid contract, and then certain defect arises and the agreement becomes void or the contract becomes void, then only we call it as a void contract. So we must distinguish between the void contract and void agreement. Void contract may better be called as a void agreement to avoid the contradiction in terms. Next is voidable contract. An agreement which is enforceable at law at the option of one or more parties thereto, but not at the option of other or others, is a voidable contract. This is a definition as per the Indian Contract Act. Now, what is mean by that? It means if the agreement is voidable, means avoidable by the one or more of the parties thereto. These are the parties whose consent is not taken freely. Yes, if the free consent is missing, in case the free consent is not taken freely, if it is taken by coercion, undue influence, fraud, misrepresentation, then the contract becomes voidable at the option of the party whose consent is not taken freely. So those contracts are voidable contract. Such contract is good until it is avoided. Unless and until the parties whose consent is not taken freely avoid such contract is a valid contract. Once it is avoided, it becomes void. Suppose a party whose consent is not taken freely wants to avoid the contract, in that case only the contract will become a void contract. But if the party chooses to affirm it, means the party wants to continue with the contract, continue with the terms of contract, in that case the contract will be a valid contract. What are characters of the voidable contract? It is valid and binding on both the parties so long as it lasts. Unless and until the party whose consent is not taken freely wants to avoid the contract, it is valid and binding on both the parties. The law gives an option to one of the parties to avoid if he so chooses. Only one of the party has the right to choose whether to continue with the contract or to discontinue. The party entitled to repudiate the contract is not bound to repudiate it or but may affirm it. In that case, the other party remains to bound to carry on such agreement. So suppose the party whose consent is not taken freely wants to continue the contract, then the contract is a valid contract and both the parties have to fulfill their part of promises. None of the party now cannot move out of the contract. Both the parties have to perform their part of promise. For example, a person of weak intelligence made a gift of his entire property to B, who was in a position to dominate him. The gift having been obtained by undue influence is voidable at the option of A. Here, A is a person of weak intelligence, means he is not a party competent. But in certain situation, he has the intelligence. In that case, suppose he enters into contract, in that case, the situation will be different. Now, it is up to A, the person who is of weak intelligence, whether to continue with the contract or to discontinue. Another example, X intends to deceive Y by falsely representing that 500 moles of indigo are made annually at X factory. Now, here Y is a party whose consent is not taken freely because here is a misrepresentation done by Mr. X. Now, here the contract is voidable at the option of Y. Now, Y can either continue and take the advantage to repudiate the contract. Voidable contract is voidable from the very beginning only. For example, where it has been induced by coercion, undue influence, fraud, or misrepresentation, then it is voidable from the beginning only. But of course, ultimately we have to decide whether it is valid contract or void contract. The defect in voidable contract is not incurable and if condoned, it can become a valid contract. Suppose there is a defect. Defect means only that the free consent is not taken freely. The consent is not taken freely. This is a defect in the voidable contract. We cannot cure it because the consent is already taken. We cannot cure it. But if that defect is condoned, means ignored, in that case the contract becomes a valid contract. The party rescinding the contract is entitled to get the damages for any loss that he might have suffered from the other party on account of making the contract. Suppose the party whose consent is not taken freely wants to rescind the contract, wants to cancel the contract. In that case, that party can get the damages from the other party if he has suffered some damages. But in case that party has received some benefits from the contract, the party whose consent is not taken freely, that party who has the option to cancel the contract has taken some benefits from the contract. In that case, that party has to remit those benefits, or that party has to restore those benefits to the other party if he wants to cancel the contract. Next is unenforceable contract. It is a contract which is otherwise valid but cannot be enforced due to some technical defect. Yes, there is a absence of written form, or there is a absence of stamp is a technical defect to make a contract enforceable in the court of law. For example, whenever we enter into a promissory note, whenever we draw a promissory note, whenever we draw a bill of exchange, we know that we need to paste a stamp on it. Those stamps are of specific value. As per the state to state, they differ. Suppose one of the party has failed to paste that stamp. In that case, there is a technical defect, and that bill of exchange or that promissory note cannot be presented in the court of law as a proof. So this technical defect, of course, can be rectified, and that contract can be become a valid contract. Such contract cannot be sued upon by one or both the parties to the contract. Such contracts cannot be proved in the court of law due to that technical defect. Suppose there is a contract between the parties which is not written down on the paper and not registered. For example, in case of partnership in India, the partnership deed must be in writing, and it must be in registered form in case of the partnership is registered in Maharashtra. This rule is applies only for the state of Maharashtra. So if the partnership is not registered in Maharashtra, then we cannot prove in the court of law that there is a partnership between the parties. So such kind of contracts will not be enforceable by the courts unless and until such defect is rectified. Of course, we can rectify that defect and can treat that contract as a valid contract. Next is illegal contract. A contract which is either prohibited by law or otherwise against the public policy, it will be called as a illegal contract. It is either prohibited by law itself, or it is against the public policy as per the court or as per the law, then it will be called as a illegal contract, and such contracts are void from the beginning only, that is void ab initio. Thus, a contract to commit a dacoity is an illegal contract. Dacoity is an illegal activity as per the law. It is prohibited by law. Thus, the contract to enter into or the commit the dacoity is illegal contract, and it cannot be enforced in the court of law. An illegal contract should be distinguished from the void contract. Of course, all illegal contracts are ultimately void contracts because they cannot be enforceable in the court of law. But all illegal contracts are, of course, void contracts, but all void contracts are not necessarily the illegal contracts. For example, wagering means betting. Betting and gambling, of course, it is a void contract, but it is not necessarily illegal. Every void contract is not illegal unless the object or consideration is immoral or opposed to public policy. If in case the contract is in which the object is immoral or opposed to public policy, then that contract will be an illegal contract, and then ultimately it will become a void contract. Void contract does not affect the collateral contract. Now, collateral contract is a contract which is based on other contract. Means two contracts are related to each other. In case one contract is void between that collateral contract, the other contract can be continued. But in case of illegal contracts, if there is a collateral contract, the other contracts is also get defected or is also get infected, because the illegal contract is like a infectious disease and is fatal not only to the main contract but also to the collateral contract. For example, X borrows rupees 5,000 from Y for the purpose of smuggled goods. Now, borrowing rupees 5,000 is not illegal. So this contract is valid contract. But borrowing the rupees 5,000 for smuggling goods is a illegal activity, because smuggling of goods is illegal as per the Indian laws. Why knows the purpose of loan? Now, the money lender knows the purpose why Mr. X is borrowing that rupees 5,000 from him. In this agreement between X and Y, the collateral agreement is smuggling of goods. So, the main agreement also becomes illegal. Thus, both the agreements become illegal. We will see the other classifications later on. Thank you.